Maybe I should step away. I'm not sure how to deal with the feedback problem. Okay, I'm not going to, as I've said, get into the bios. Lorraine Weinrib is our next speaker, who's going to kick off the key principles session of the conference. Lorraine is known to everyone, and certainly to anyone and everyone who's ever studied Section 33, written about it, adjudicated it. She's Professor Emeritus of Law at U of T, senior counsel to the Ministry of the Attorney General for decades, and one of the key writers who really got the literature on Section 33 kicked off with a very well-known piece in 1990. Lorraine, we're delighted to have you. The floor is yours.
Okay. Thank you very much. It's a great pleasure to be with you, even if only on a Zoom. And I must commend the organizers for realizing that it was time to revisit Section 33. We tend to only get excited about it when there's active contemplation or actual implementation of Section 33, but we really must work hard on working out some of the quirks so that we don't find ourselves in jeopardy of undermining the Charter's purposes. And this is why I named my presentation Norms and Exceptions, because what I want to stress in my presentation is that Section 33 is an exception to the aspirations and the implementation features of the Charter, and that we must treat Section 33 as an exception and circumscribe its use according to its exceptional status. In the aftermath of the Second World War, rights-based democracy became the desired model of governance, inspired by the UN Declaration of Human Rights and operating under the international covenants and various regional rights protecting instruments to which Canada and the federal government and the provinces together have bound themselves. The animating principle is to correct the demonstrated failings of democratic government, to respect the equal and inherent dignity of all persons, and by extension, the groups to which they identify and the affiliations that they espouse. Domestically, the Charter marks fidelity to and rejection of Canada's various egregious departures from the idea of equal and inherent human dignity. We have positive models, including in our historical implied Bill of Rights jurisprudence championed by Justice Rand, and the statutory protection of rights and freedoms at the federal and provincial levels, and common law protections. We have also negative experiences, often imposed by legislatures, that were disrespectful of human, legal, political, and equality rights. And we all started law school, those of us who went through that process, learning about the egregious treatment of the Aboriginal peoples, political and economic discrimination against immigrant groups, the Chinese and the Japanese in the early cases, religious minorities, women, sexual minorities, the disabled, etc. Statutory protections proved inadequate, and the project of entrenching rights began. And Tom has given us a wonderful overview of that process. The final terms of the Charter were forged in the Special Joint Committee of 1980-81. The Joint Committee provided extended televised parliamentary hearings that attracted wide civil society and expert participation and extraordinary civil society support across the country in every province. One can't imagine stronger legitimacy than that which attaches to the work of the Joint Committee, which strengthened the Charter's rights and freedoms, endorsed judicial review and the access to remedies, and provided a strong principled limitation clause based on international and comparative models in the British Empire. This structure replaced an enormously deferential legislative supremacy positive limitation clause. And this, I think, precipitated the desire of the provinces who had put forward this deferential limitation clause to advocate for the override. Those who opposed the Charter were agreed in their opposition, but not in the underlying reasons. For some provinces, the problem was the reduced status of the provincial community as the authentic community. And so, for example, since Tom mentioned the proposed federal preamble to the constitutional amendments expressing the voice of the people of Canada, the premiers who opposed the Charter opposed the expression of "we the people of Canada" in a preamble, and that's one of the reasons we unfortunately have no preamble. Other premiers based their opposition on the constraints that a Charter would impose on legislative jurisdiction, and other premiers opposed what they perceived as the potential subordination of traditional and or local social, religious, and moral values as a result of rights protection. And of course, some premiers had other reasons or had various combinations of these reasons. What I want to focus on today is the significance of having an override as an exceptional clause in a constitutional amendment that entrenches a charter that embodies the ideas of rights-based democracy desired by the people of Canada in the joint committee proceedings, which constituted the only constituent opportunity that the general public in Canada ever had to formulate the supreme law framework of their relationship with the state. We exhausted ourselves in the constitutional amendment debates in 80-81, and of course that was the culmination of almost 30 years of debate in providing the structure that the Constitution Act gives us. We did not create new institutions, and so we had one of the most difficult transitions to rights-based democracy. Much easier for failed states or defeated states to adopt this model from scratch and create new institutions. The Supreme Court of Canada bore the strongest burden in implementing the litigation arrangements for the Charter. In my opinion, it carried out this adaptation responsibility admirably, because I would like to remind you that in a lot of the debates about adopting a charter, one of the concerns was not the substance, but whether the Supreme Court of Canada would be able to perform its rights protecting adjudicative responsibilities in line with rights-based democracy. In a series of well-researched methodological cases which reflect the careful study of the models of rights-based democratic systems in the international, regional, and national levels, the court drew on the rights-based elements of its own prior jurisprudence to delineate the remedial purposes of rights-based democracy generally, but also to establish purposive interpretation, the two-stage analysis, the shift in onus as between the delineation of the scope of the right and its infringement on the rights holder, and then the state carrying the shifting burden to justify the infringement, if it could, based on the principles of the Oakes test. In tandem, the court also, in a number of blockbuster reference cases, developed its capacity to address constitutional questions based not on the actual text of our constitutional arrangements, but based on foundational constitutional principles drawn from our British heritage and the more modern post-Second World War principles of rights-based democracy. In effect, the court worked on a case-by-case basis to transform our old, fragmented, outdated constituent structure rooted in the British Empire into a comprehensive framework for the operation of an independent, modern, federal, rights-based democracy. In effect, the Supreme Court of Canada transformed itself into a constitutional court, which is an almost necessary institution within rights-based democracy, and carried that load in addition to its Supreme Court responsibilities. This was an impressive accomplishment, and it was quite confusing for people who were not familiar with non-British constitutional development or the way in which the common law and the civil law had been combined at the international and regional level to create the framework of rights-based democracy. In stark contrast to that miraculous accomplishment of the Supreme Court of Canada on the Charter and on the constitutional principles, the court literally flinched when it deliberated upon the major, and actually the only case on the override, the Ford case, in which I represented Ontario. And while it seemed like I was in the Ontario government for decades, it actually wasn't that long. But even though I was fairly junior to be arguing Supreme Court cases, I was able to do that because I was superbly trained by my mentors at the Ministry of the Attorney General in Ontario. And I was privileged to, from the time I was an articling student in the mid-70s, to not only follow the political developments of the constitutional battles, but also to sit in at the Supreme Court in all of the major cases, and then to start doing interventions, I think when I was 5 years from my call to the bar. I knew the court very well, and my aspiration as a litigator was to be able to answer questions from any one of the judges on the Supreme Court differently, depending on my understanding of the mindset of that judge. I was absolutely astonished at the first question that Justice Lemire asked me when I started my submissions in the Ford case. Madam Weinrib, he said, are you asking us to judicially review the exercises of the override clause? Do you realize that this institution is totally overwhelmed with charter litigation? No jurisdiction has been taken away from our docket. And I replied, yes, my lord, as we said then, that any grant of jurisdiction has to be reviewed for any exercise under it. But that was a signal that the arguments that I was going to make, challenging Quebec's use of the override, were going to be an uphill battle. Quebec used the charter's override in an unexpected way, and I call it a maximal override. It used a boilerplate formulation referring to all the sections that are overridable. So that's the boilerplate feature. The second feature was the omnibus feature. In a complicated way, it made sure that every statute on the books and every new statute subsequent to that and every amendment to any statute in the future contained this boilerplate override prospectively. But it had a problem. Quebec wanted, I assume, to prevent any charter litigation in Quebec. It didn't want Quebecers to understand and enjoy the benefits of the charter rights that they had acquired with the entrenchment of the charter. So for reasons I don't understand, but maybe just because of the time it took to figure out what the response would be to the charter being adopted without Quebec's consent, they didn't get their act in order to impose these boilerplate prospective overrides in time for the charter's actual implementation. This legislation of maximal override came into effect 3 months after the charter came into effect. So in addition to this pervasive omnibus prospective override policy, it also had to cover that 3-month period from April to June 1982 to prevent the charter from coming into effect at all, and they had to do that retroactively. I think that as I remember, I don't have all my notes from the litigation file, but I was the only one who argued this. It wasn't argued in the Quebec Court of Appeal, and so I had to carry the load on the retroactivity myself. The Quebec Court of Appeal had done an excellent job on the boilerplate and the omnibus application in all statutes. In terms of the boilerplate, they said that it was just inconsistent with the language of the charter. The charter doesn't say you can override the charter. The charter doesn't say you can override sections of the charter. It says that you can override provisions in sections. And so just using the boilerplate sections 7 to 15 is completely inconsistent with what the premiers asked for and what they got in the compromise. In terms of the omnibus, the court took a more general view, not based on text, but based on constitutional principle. It said it was incoherent to have so many overrides and so many statutes where the charter wasn't conceivably engaged. And it gave the example of the Sugar Refinery Act. Now, in the Supreme Court, I addressed those arguments. I had much more time to prepare them than the people who worked on them for the Quebec Court of Appeal. But the main original thrust of my argument was the retroactivity. The retroactivity point was, I thought, very important for two reasons. First of all, the rule of law, but no one would know at any particular moment what their rights were, because on a Thursday, when you would like to go out and demonstrate against the provincial government for something, or the federal government for that matter, you wouldn't know if next week that legislature would convene and retroactively take away the rights that you had exercised when you enjoyed them in real time, but that were negated retroactively by use of the override. So I thought that was very simple. But the other thing, and I got tangled up with Justice Lemaire on this issue, and and I think it's an important issue that if the override can be used retroactively, then it gets very complicated as to how the 5-year limit operates, especially if you have a huge number of of clocks ticking on the 5-year duration of the various statutes. And of course, the way Quebec had done it, it had both retrospective and prospective override instruments operating in respect to individual statutes. So I think that for those two reasons, the retroactivity is a very bad idea. The Supreme Court of Canada, unlike the Quebec Court of Appeal, did not use the rights-based democracy principles in rejecting the boilerplate and omnibus features of the Quebec Court.
Lorraine, I have to ask you to wrap up because we are.
Fine. Just a few more sentences, sure.
Yeah. Thanks.
So the court used statutory interpretation methods rather than constitutional principles or principles of democratic government, and this was shocking given the sophistication of the other approaches to the charter litigation. We now stand at a precipitous moment in terms of the override. Recent activity in Quebec and Ontario on the override has brought back the question of retrospectivity. It's brought back the question of adequate democratic deliberation, and it has raised the question of fast-track use of closure, sessions which don't have full committee work, and even the prospect of not only retroactive invocation of the override, which denies democratic deliberation, but also the use of the override in electoral context, which is shocking in terms of the idea that rights-based democracy protects democracy against some of its more counterproductive and unprincipled behavior. Now, another point I want to raise, just in closing, is that there was, oddly enough, quite a bit of discussion about Section 33 in the oral argument in the Ontario City of Toronto election case in the Supreme Court. And Justice Brown seemed to express the view that you can't use unwritten constitutional principles to interpret Section 33. This means that we're back to the text, and the court has already signaled previously that the international ethos of rights protection is not available for charter interpretation. All of these elements throw us back to the text. So I think that just as in the Ford case, I was able to succeed in limiting the override by very, very strong arguments rooted in text. And even though the Supreme Court of Canada has broadened its engagement in purposive interpretation, that future cases may really depend on exploiting the textual coherence and architecture of the full constitutional text, not just the charter, as much as possible. Thank you.
Thank you so much, Lorraine. I really do wish that every speaker would have, at least an hour, because I know you're just scratching the surface, and very grateful for your talk. Our next speaker is Dwight Newman. He's written more books than I've read in my lifetime, and he has been cited with approval by the Supreme Court of Canada, and I can't wait to hear his talk today. You can read the bio with all of the details in your program. Dwight, the floor is yours.
Well, good morning, and thank you for holding such an important conference and bringing us together to discuss these themes concerning the Notwithstanding Clause. I'm going to offer a pro-Notwithstanding Clause talk, perhaps unsurprisingly, given my past claims. And in essence, I take the view that the fact that constitutions come from historical compromises is not a reason to continue to read them in compromised ways or to read particular clauses of the Constitution in compromised ways. To speak of a particular clause that made its way into the constitutional text in a way that delegitimizes it actually has risks for all the other parts of the Constitution that were compromises as well. And there was reference earlier to the minority language rights clauses of the Constitution. The Supreme Court of Canada has been at pains to move away from a view initially argued by many that they should be read in limited ways because they came from compromises, to instead put a fuller meaning on those terms. And I would argue that in some ways there's an analogy for the Notwithstanding Clause. To argue that the Notwithstanding Clause should be hemmed in by new restrictions or new restraints beyond those in the text, or to speak of it as something to be embarrassed of, as has so often occurred in discussions about the Charter, is to miss the possibilities of seeing how it in fact is part of a unique Canadian Constitution, and one that speaks to many features of Canada differently than a constitution of some other country would. So I'm going to try to briefly set out three key things that the Notwithstanding Clause does as part of the constitutional text. But in doing so, I'm ultimately arguing simply for seeing it as part of the Constitution, letting it live as part of the Constitution, and not taking the view that there should be special restrictions put upon it, even based on the rest of the Constitution, as has been one recent argument in a few different variants by different scholars, all of whom have great arguments. But at the end of the day, if one's going to try to read the Constitution in a coherent way, to read it as a coherent text, it's not that the Notwithstanding Clause needs solely to be hemmed in by the rest of the Constitution. The Notwithstanding Clause also tells us something about the other clauses of the Constitution as well. It's part of a unique structure to the Canadian Constitution, to the Canadian Charter of Rights specifically. And Canada did not go an entirely American route, as many point out in the context of something like Section 15, where Canada deliberately drafted the Charter differently than in the American context to avoid problems that the American context had encountered, as Canada attempted to do in the context of Section 7 of the Charter, where there were attempts to avoid certain paths that the US had ended up on. Now, the Supreme Court of Canada didn't stick to that text for very long, as it turned out, but people still point out the various ways in which Canada's Constitution was meant to be different than the American Constitution, and specifically the Canadian Charter of Rights was meant to be different than the American Bill of Rights. Well, I'm going to talk about institutional roles in the Canadian context, talk about democratic participation in the Canadian context, and talk about diverse identities in the Canadian context, with all of these linked to particular contributions of the Notwithstanding Clause in the Canadian constitutional text. In respect of those institutional roles, Canada's Charter of Rights is not the American Bill of Rights, as I've already alluded to. It's an error to read it as such for a variety of reasons, and in a variety of specific contexts where there were drafting choices made differently than in the American context. And we could add to those Section 1 of the Charter, to those that I've already mentioned. Well, Section 33 of the Charter is also something different than in the United States. And we need to give content to the different features of the Canadian Charter. Section 33 wasn't some random last-minute addition by some drafter in the middle of the night, even if there were historical events that involved discussions in the middle of the night. But it continued from previous Bills of Rights in the Canadian context, some of the provincial Bills of Rights, from the Canadian Bill of Rights from 1960. It was part of the context in which drafters were operating. There were discussions of the possibility of including a notwithstanding clause throughout various phases of the constitutional discussions of the 1970s, well, even from the late 1960s, amongst our many rounds of constitutional negotiations, many of them over the amending formula. But in the 1970s, this was a very live possibility to include a notwithstanding clause, and one that had support from a number of provinces specifically thinking about it. Alberta, Saskatchewan, Quebec all had particular interest in the notwithstanding clause. And Alberta and Saskatchewan, we know about their premiers speaking on behalf of the notwithstanding clause. We can add Quebec introducing a draft version of the Charter at one stage that contained a version of the notwithstanding clause as part of the discussions. This was something present within the Canadian ideas of the era. We've heard about reference to Paul Weiler's article, of course, that also informed some of the discussion at a latter stage. Notwithstanding clause, the discussion of that idea was entrenched in the context of seeking balances between a parliamentary tradition and an American style of Bill of Rights. And those that read the Canadian Charter too much as an American Bill of Rights miss part of that balance in some respects. So that's one dimension here, is that historical dimension. But there's also a broader tradition at stake. And there was reference earlier to Stephen Gardbaum's Commonwealth models of constitutionalism. I think that's an important broader political theory consideration to take account of. That Commonwealth models of constitutionalism have taken a variety of forms that don't all involve strong form bills of rights, but involve a more nuanced role for a Bill of Rights instrument alongside the parliamentary tradition. And it's certainly the case that our discussions bear on liberal democracy generally, but we shouldn't rush to assume that a notwithstanding clause undermines the idea of liberal democracy, unless we're going to say that the United Kingdom, Australia, New Zealand are all to be condemned as rogue states outside the bounds of liberal democracy. Within these Commonwealth models of constitutionalism, there can be a role for judicial interpretation of rights, even while there's an ongoing role for parliamentary interpretation of rights, and that special form of coordinate interpretation that has gone on in many respects over the centuries within the British parliamentary tradition. The longest form of liberal democracy in some respects to survive over the centuries in some place in the world, in a world where liberal democracies haven't been a form of government to prevail over much of the world over much of time, if we look in broad terms. So I'm going to turn next to the issues of democratic participation. And here I would highlight part of what the Charter of Rights leaves outside the scope of the Notwithstanding Clause. Here, outside the scope of the Notwithstanding Clause, in addition to minority language rights and a number of subsequent provisions of the Charter, also left out of the scope of the Notwithstanding Clause in the middle of the Charter, in the middle of that 2 through 15 section, sections 3 through 6 are not subject to the Notwithstanding Clause. Fundamental democratic rights and mobility rights, rights of voice and rights of exit are outside the scope of the Notwithstanding Clause. And this speaks to the relationship of the Notwithstanding Clause to other considerations. The Notwithstanding Clause is there to support democratic participation and can't be used to undermine it. In so acting, the Notwithstanding Clause preserves rights that aren't otherwise enumerated in the Charter other than implicitly within those provisions. And in some of my writing on the Notwithstanding Clause, I've talked about Jeremy Waldron's discussion of the right of rights, the right of democratic participation, and the idea that if rights become a subject only for courts, if rights affect too much policymaking, as they should, but if rights affect a broad scope of public policymaking, and if rights are within the purview only of courts, one places a great deal of public policymaking solely within the hands of courts, or subject to the ever-present shaping of that policy by courts, without giving as much chance for democratic participation as there could otherwise be. And of course, I'm simplifying some things here in terms of a set of considerations related to dialogue theory and so forth. But at some level, if one says that one can never make a decision on a particular policy without the expert guidance of the courts, one's surrendering too much to an expert guardianship. And the guardians of rights have become our guardians in some concerning ways. There's a much more complex scheme that's fully appropriate, that sees both courts and parliaments engaging in interpretation of rights. A fair critique against that would be that parliaments don't always seem as concerned for rights as we wish they would be. And we don't see the kind of dialogue in parliaments that we would like to see on rights issues or on anything else. There are many commentaries that are critical of a lot of what goes on in parliamentary democracy in Canada today. I would raise some questions about cause and effect there. I've not conducted an empirical study to make this claim, but one can at least pose the question of whether in describing parliaments as incapable of protecting rights, we can render that conclusion possible in a way that it wasn't before. If we're too critical of the possibility of parliaments getting better at protecting rights over time, do we say they no longer have a role in that? And there can be a concerning reverse causality that takes place here. And the whole discussion around the role that courts have taken up in recent years, and the readiness of parliaments to permit courts to make a lot of public policy decisions because that's easier. In some ways, this can be related to a concept of courts as sole interpreters of rights. And in fact, democratic participation on rights calls us to a stronger democracy in some ways, calls us to a better democracy, and calls us to a democracy in which the people must engage in rights discourse in the ways that, for all its imperfections, one can find many traces within the parliamentary tradition and parliamentary history over the centuries. So I'll conclude with this last point about the diverse identities in Canada and the way in which the Notwithstanding Clause relates to those. We can talk over time over how many times the Notwithstanding Clause has been used. Depending how you count the Quebec Omnibus use, one could say that there have been hundreds of uses of the Notwithstanding Clause. But leave that aside, there have still been more uses than are often realized. But the other thing I'll point to within that is that there have been more uses to protect minority rights than often realized. Here, at a qualitative level, the recent Saskatchewan use stands out in some respects, where a court was going to strike down rights of minority religious communities, and the Saskatchewan legislature acted to preserve those, as well as to fend off chaos within the school system during the period in which that decision looked like it might come into force and parents and children were making decisions about schooling. But if one goes back through the history, some of Quebec's uses after the omnibus use concerned uses to preserve certain forms of representation, including Indigenous representation. Yukon's early use was worried about whether the interpretation of Section 15 of the Charter by the courts, not yet known at that point, would interfere with Indigenous representation in some governance contexts, and enacted a use of the Notwithstanding Clause, not ultimately necessary, not ultimately proclaimed as a result, but that would preserve minority representation, and specifically Indigenous representation. So there have been contexts in which courts have been a threat to minority rights and parliaments have been the protectors. Beyond this, though, the Notwithstanding Clause was discussed in the dialogue amongst the premiers at one stage as allowing for different provincial choices on some issues. Premier Blakeney talked about the idea that it could help to preserve rights that weren't in the Charter, such as socioeconomic rights, against courts that would strike those down. Well, it allows for different provinces to make some different choices at the margins around some rights issues. And Canada doesn't have a charter that's identical across the country in some respects. The province of New Brunswick has a different charter text than the rest of the country through the use of the bilateral amending formula in the addition of Section 16.1. Some other provinces have made choices to balance certain other rights differently. And the Notwithstanding Clause enables that preservation of diverse identities within Canada. That's a case for the Notwithstanding Clause. There will be many critiques of the Notwithstanding Clause to come, I'm sure, and I'm just delighted to be part of this dialogue and this conference on such an important topic.
Dwight, that is so brilliant, as I knew it would be, and there's so much for us to discuss. I hope we're going to have a chance over the course of the coming days to take up some of your very, very compelling arguments. Thank you so much. Nathalie, the floor is yours.
Merci beaucoup. Thank you very much. I've entitled my paper Conjuring the Evocatory Power of the Notwithstanding Clause. I'll start with a little story and then I'll move to the 3 points that my paper are making. During the summer of 2018, the Ontario legislatures, the MPPs, debated the appropriateness of using the Notwithstanding Clause to immunize from charter scrutiny a bill that sought to cut the City of Toronto Council in half in the midst of a municipal election after an Ontario judge had found it to be a violation of freedom of expression. I was there. So don't think that I want to make sure that I believe that all branches of government have a duty to support, enhance, and protect minority rights, protect charter rights. The charter is a floor, it's not a ceiling, and therefore all branches have a special duty to actually respect the Constitution and reflect it. So I was there and I was trying to convince my colleagues that the preemptive use of the clause was unwise, that it would set a precedent that all governments of all stripes would use just because they could, and that ultimately it will diminish rights protections for everyone. And I described to many of my colleagues that were there that because I knew their stories, that many of them had benefited from charter protection, that anyone who was a refugee or a child of a refugee had benefited from the due process imposed really early on in the same case in the charter, that people that were homeschooled had gained protections from the freedom of religion in Jones, that LGBTQ struggles had been helped by the charter, that women's access to parental leave was a product of the charter, that journalists had been protected, adoptive parents, and anyone who had or whose family had had any dealings with the criminal justice process gain additional protections through the charter. I then move on to say, well, and the dialogue theory is really a response to some of the fears that were expressed by the premiers in 1981, 1982, because the courts have internalized institutional limits. Some say too much, but certainly there's wide scope for parliamentary supremacy. Governments do continue to contribute both to the enhancement of rights, to the development of their social policy, and the dialogue theory provides a deliberative democracy with the tools it probably needs. At the time, as Tom mentioned, I think many of my other colleagues mentioned that the voices from the deal, so to speak, from the compromise, were expressing the view and were publicly stating that the clause was never meant to be used preemptively, and it was a tool of last resort, or as they said, a guarantee that elected officials would be the one making the last mistake. After we all spoke, one PP from the other side of the aisle rose to make his pleading in favor of the use of the clause, and he said, the Constitution is a living tree, and whatever the initial drafters of the clause meant, it can and must change and evolve. And he suggested that the Notwithstanding clause in 2019 should be read as an empowering tool for government to decide what was good for the public, what was appropriate for the public good. They should do what they saw fit, was the terms. I could not respond at the time because my time was up. So this paper is a little bit of way of responding to that. So I want to say three things. I'm going to make three arguments. The first part of the paper posits that the use of the Notwithstanding clause is a dangerous tool, that it also is probably unnecessary, that the mischief that the drafters sought to avoid has not been fully realized. So I make two claims. The first one, that it is dangerous because it has the risk of undermining the entire edifice of the Charter. It has the risk of minimizing international human rights protections to which we are bound. And secondly, that its use is probably remedied by the way in which the court have internalized lots of limits and the way in which they've interpreted Section 1 particularly. So my second part, though, is it's here, and certainly the MPP that suggested that we are in a living tree and the Notwithstanding clause should be interpreted in 2018 and 2022. So I make the claim, my second part is, what do we do now? Seems to me it should be interpreted restrictively, and that speaks to two different constituencies. Part 2 speaks to what the courts should do with the use of the Notwithstanding clause, and Part 3 says, what can we do as civil society, and particularly as elected officials, could do to engage with the debate and continue to suggest that the Notwithstanding clause should be interpreted restrictively and that its use should be compatible, as Dwight says, with the purpose for which it was initially intended. And for the purpose that the language supports, that Lauren talks about and that also Dwight mentioned. So if I may start then with the Part 2, about the way in which I think I suggest that a modified Section 1 test could be deployed to impose on governments the duty to justify their use of a Notwithstanding clause. And in my view, that engages fully with the deliberation, the power of deliberation that is necessary in a democracy. It forces the government to explain why it is necessary to use that tool and why it is compatible with a couple of things. And let me just raise my case here. So the government should bear the burden of defending its preemptive or even its use of the notwithstanding clause on a modified Oakes test. It should identify a legitimate objective, not a political timing issue. It's not sufficient to say, I'm in a rush to get done everything that I promised to do. I think it must do something a little bit more, related more, I think, to the emergency. I can imagine the examples, for example, trying to curb the anti-vax demonstrations in a way, for example, where they would have been challenges in the courts, and the courts would have decided that they were not, they were protected by freedom of expression, and a stay had been not granted, for example. So you can imagine some emergency aspect where you could justify maybe the use. I think the government should then have to consider and explain why it considered other options to resolve the tensions, in particular the application of a stay of the decision. It should also, in my view, explain why to invoke the notwithstanding clause is compatible with the unwritten principles. And I know that Lauren said that maybe the unwritten principles are gone forever. I disagree. I think that they will continue to be a way in which the unwritten principles can be used to fulfill gaps. And there are gaps in the way in which Section 33 is written. So I would say that it would be appropriate to refer both to using democracy principles, rule of law principle, protection of minorities principles, and also whether it is compatible with international human rights law. So let me say why I think that this test would indeed be an appropriate way and would, I think, facilitate reconciling the different visions that we have and that are present today about the notwithstanding clause. I think that in general, I think people would say that the Charter has been a good thing for our public policy. It does not replace governments. Au contraire, I think I would argue that governments have not been prevented from acting and from carrying on their agenda. On the contrary, I think many of the Charter case have evolved and have responded to pressing issues that have been helped by both debates in the legislature or parliament and debates within the courts. So in my view, the Charter continues to be there to protect the minorities that are not heard in politics. The weak, the powerless, the unpopular, the ones who do not vote or are not heard. The immigrants don't have the right to vote. The incarcerated people whose capacity to influence policy is minimal, children who do not have the right to vote. And pretty much all marginalized people would feel that they're not sufficiently protected now, but certainly I think would say that maybe they should have been more protected, but to abandon chartered protection as a potential vehicle for social justice would be a mistake. So in my view, I think the only possible rationale for using the notwithstanding clause is timing. Post Supreme Court of Canada decision, a government may consider the impact of the decision to be too large or may cause havoc within a society. But preemptively, before the matter has been risen or been dealt with the Supreme Court, I see little justification for it except in terms of emergency. To me, the balancing of rights versus expediency is never the right call. That's the reason, despite the alleged urgence of fixing Toronto's governance, I believe it was wrong to use the notwithstanding clause. The changes could have waited for the next election. In any event, I think the suggested test that I propose would demand a government justifying its use of notwithstanding clause in a way I think it would respond to what Professor Leckie Dean Leckie has suggested, that courts should continue to debate and decide whether indeed the notwithstanding clause was ever necessary, because if they were going to consider that it was justifiable under Section 1, at least we are better off and we know a little bit more. And declaring that rights have been violated is in itself a good for our society. Nevertheless, I think one of the danger, if there is no possibility of demanding of the government to use it, to justify the use of the notwithstanding clause, that people will stop suing and will stop using litigation once the notwithstanding clause has been used. Why would you do this if the only power that you're getting is going to be a declaration? So I worry that unless we demand more and demand justification, it may prevent us from actually having a full deliberation on all of the tensions. Let me say one of the other things that I put in my test is whether indeed deference should be given to the government in that. Right. And here I refer to the work of Aileen Kavanagh, who's a British scholar, who continues to say that if we are going to assess whether deference should be given to the legislature, we should make sure that they actually do their job. So she demands actually, and she suggests that deference should only be granted to the extent that the issue was debated fully in the legislature. So her question is there evidence that Parliament or the legislature has addressed the human rights issue, has focused on the debate, as it's subjected to extensive discussion, to deliberation? So she suggests, for example, that committees should be seized with exploring this, and that it be done in an inclusive debate, welcoming participation. So the idea of using the notwithstanding clause in a way in which it curtails debate and not have committee decisions and participation, I think she would suggest is dangerous. At the same time, I think I want now to move very quickly to the third part of my paper, which is, in any event, it is here to stay, and civil society should do something about this. Obviously, we would want everyone to know more about the clause and react strongly when it is being used, punish governments that use it. We suspect that there's very little political cost to using the notwithstanding clause. Who knows whether Legault and Ford may be both re-elected, and despite the fact having using the clause maybe in the wrong way. Christine Good, in some of her work, suggests that we should engage more into a manner of form limitations. And she suggests in a different context, so I just want to, put that on the table. But she suggests that maybe, and I think Tom alluded to this, maybe there is a need for different legislation to be enacted to say, if we're going to use a notwithstanding clause, we're going to use it with an extra majority, with special committee, and with probably a heightened majority of 2/3, for example. So I have to say that shortly after the use of the threat of the use of the notwithstanding clause in the Ontario legislature, we suggested that by a private member's bill, that something like this be put forward. I encourage everyone to actually demand that of their elected officials. And we should do it outside of a period where it's fraught with the difficulty of reacting to its use or its potential use. So in my view, I think there are things that we can do to actually look at the notwithstanding clause in 2022 and react to the danger that it poses in a productive way. So in conclusion, the notwithstanding clause should have, in my view, remained somewhat of a dormant clause, a relic of this important compromise and debate surrounding the limits of judicial review that occurred in the early 80s in designing rights protection mechanism. At the time, the question was very much who should be trusted to better protect the vulnerable. A group certainly reflected that elected parliamentarians were much better equipped and more likely to do so than a group of disconnected elite jurists. Other believes in the power of rights in having a recourse to a non-elected, unbiased people who would listen, adjudicate, listen to individual voices, and provide a complement and a thoughtful ear to people that were affected. To me, the story of the last 4 years was that by and large, it's not a zero-sum game. Both the legislative and the judicial branches have a role to play to actualize the promises of an equality and of democracy. The resurgence, I can't speak English on Monday morning, of the debate around the Notwithstanding Clause reveals more about our political system than our judicial system. That we have elected people who are prepared to use all tools at their disposal because they can, have a certain disdain for the Charter because either of ignorance, of nationalistic views, or political calculations is more about populistic types of politics that have migrated from the South. Populist politics may be here to stay, and the temptation to use the Notwithstanding Clause will remain as a tool of power, as a tool of authority. I can do what I want because I won, may be with us for a while. It is therefore incumbent to propose ways to minimize the dangers and propose a framework for its limited use that refer to our constitutional framework, Section 1 test, international human rights, unwritten principles. And I do hope that the courts never have to use that framework because civil society will have reacted and indeed push forward for additional limit being done within the political sphere. Nevertheless, I think this paper suggests that the power of the Notwithstanding Clause should be addressed in the courts through a demand for greater accountability and through civil society actions as we move forward with continuing to have this relic of the Notwithstanding Clause. Otherwise, we risk losing many of the accomplishments that we have had over the last 40 years. It's time to conjure the power of the Notwithstanding Clause. Merci.
Merci, Nathalie. One of my favorite bluesmen, Joe Bonamassa, has a great song. It's called Just Because You Can Don't Mean You Should. But the problem is it's the reverse in this particular case. And I think Ford taught us that just because it's there means I will. I now have the privilege of introducing Jamie Cameron, who's taught more law students in this province, especially about the Charter, has appeared in the Supreme Court of Canada many times and has contributed to the literature on the Charter for all of us. I'm delighted to have you here. And you still probably are wearing the battle scars of the City of Toronto case. Maybe you'll reflect on that. Thank you, Jamie.
Thank you very much, Peter. And of course, it's a great pleasure for me to be included in this conference. And it's an honor to be a member of this panel. I will also say that I think this might be the first time in over 2 years that I've put on a dress. So it's a special occasion for that reason, too. So as we've already heard, Section 33 has been a flashpoint throughout the Charter's history. And like Lorraine and others in the room, I'm of a generation. And so it's sort of part of my history as an academic. And certainly from the very beginning, the uncertainty and the anticipation about when and how the override would be used in the early years, I have all the clippings still. I'm supposed to be cleaning out my office, but it hasn't happened yet. I have all the clippings, trust me. But then we go to a period when the Section 33 override was a standard feature in theories that Canada had found the eureka moment midpoint between the competing supremacies of legislatures and courts. And now we're in the present, and I'm really pleased to see that there has been a renewal in the scholarship in recent times. And among other things, this renewed scholarship proposes a residual role for review when Section 33 is in use. So turning to my presentation, I'm actually going to address a kind of a variation on that idea of a residual role for review when Section 33 has been used. It's a sort of I suppose it could be thought of as a narrow variation, but it's one that's important, I think. It's specific to the scope of review under Section 33 legislation, but not about the scope of review where Section 33 is in effect against Sections 2 or 7 through 15. But instead, where the override is in effect but not applicable to other parts of the Charter, namely the excluded guarantees, sections 3, 6, and 23. So I think most of us know that Hack versus Quebec provides a precedent for that in its rulings on section 3 and 23 of Bill 21. My focus today is on section 3 and Ontario's override legislation that shields unconstitutional restrictions on election discourse from review. And so for now, it's kind of a comment on Ontario's Bill 307. Bill 307 was upheld by Ontario's Superior Court at the end of 2021, and it's currently going to be heard by the Ontario Court of Appeal a little bit later this spring. I should pause also to declare that I have an interest in the litigation together with Chris Brett and others from BLG. We act for the intervener, the Centre for Free Expression. I think they're probably going to agree with what I say this morning, but I should just say they don't have to. And I'm really speaking for myself in the remarks that follow. And I guess the question is, in such circumstances, and I'll outline Bill 307 in a moment, the question is when and in what circumstances can Section 3 play a role in charter review when the override is in place. And I think Bill 307, at least to me, raises alarm bells because it's a little bit unnerving to think that Section 33 can be used against overridden Section 2B rights of democratic participation in circumstances where the goal is to protect the advantage of an incumbent government and make it easier for that government to be reelected. So you know where I stand. I was pleased to hear Dwight's presentation, and 2 points in particular. One, Dwight said that Section 33 is part of the Charter, and it therefore has something to say about other Charter provisions, like Section 3, for instance. And also Dwight said, and I agree with this as well, that Section 33 supports rights of democratic participation. So here's where I'm headed. I want to leverage Section 33 to establish a couple of key propositions. The first is that Section 33 rests on a mechanism of democratic accountability that is compromised when override legislation violates Section 3's democratic rights, and in particular, the right to vote. That's number one. And number two, Section 33's underlying principle of democratic accountability depends on and requires a robust interpretation of Section 3. And Section 3 and Section 33 are in harmony on this principle of democratic accountability. And for that reason, my argument is that democratic accountability informs both Section 33 and Section 3 of the Charter. So there's 3 parts to the analysis. The first part is textual. The second part deals with the unwritten constitutional principles. And the third turns to Section 3's process rights beyond the bare right to vote, are the right to play a meaningful role in the political life of the country and have access to information that may influence a voter's exercise of the franchise. So I'm just going to pause a second time to say that I think that there may be a little bit of overlap between my presentation and Kara Zweibel's, which is tomorrow afternoon. She's also going to speak about democratic accountability, but I think that probably we will reinforce each other without duplicating our presentations. Okay, so the context for my views about Section 33 and democratic accountability is Ontario legislation. The predecessor to Bill 307 was Bill 254, which placed serious restrictions on third-party political advertising for a full 12-month period prior to Ontario's fixed date election, which I'm not, if I'm not mistaken, I think it's on June 3, 2022. Bill 254 was declared unconstitutional by the Ontario Superior Court, and the Ontario provincial government immediately reenacted the legislation using Section 33 against all available charter rights. So this is Bill 307. This is Bill 307, in which Section 2B is ousted and cannot be used to challenge Bill 307, but Section 3 is not. And the issue in the litigation is whether the restrictions on third-party political advertising undermine the voter's right to cast an informed vote. So my objective in this presentation is to demonstrate how Section 3 and Section 33 work together to support and reinforce a conclusion that Bill 307 violates voters' rights under Section 3. So one of my key arguments is the text of the Constitution itself. And I think I'm on good ground there because that's what the Supreme Court of Canada also likes at this point in time. So we know that Section 3 is excluded from Section 33, and it has followed from that exclusion that it's a cardinal principle in the jurisprudence that for that reason and for other reasons as well, Section 3 and its right to vote demands stringent protection. That much is well established in the jurisprudence. But what I maintain is that there is more, and that Section 3 and Section 33 are explicitly linked together by the principle of democratic accountability. So we could take a look at Section 4 of the Charter. I didn't bring it up with me. And we look at Section 33(3) of the override. They speak directly to each other on this point. First, under Section 4, in the requirement of a 5-year election interval, that, in my opinion, embeds the principle of democratic accountability in the Charter's democratic rights. So that's Section 4. And under Section 33(3, the Sunset Clause is symbiotic with this principle of democratic accountability because it synchronizes the lifespan, of an override provision to 5 years and to the same principle of democratic accountability. I would suggest that this is no coincidence, and rather that democratic accountability is the bedrock principle both of Section 3 and Section 33. So speaking just for a moment to Section 33, I don't think I would be mistaken in saying that the discourse on Section 33 puts this point beyond dispute. And I have referred to all those clippings that I have that can be brought to bear to support the point. And I would go further and say that democratic accountability is clearly the basis of Section 33's legitimacy, both as to its initial requirements, and we know that they're modest, the requirements of form as they're sometimes referred to. Those requirements are modest, but they are aimed at generating or stirring democratic debate about the decision to invoke the override. But then in addition, and by virtue of the Sunset Clause, which makes any renewal of an override contingent on an intervening exercise of democratic accountability, these two features of Section 33, I think, make the point that Section 33's legitimacy depends on the working functions of democratic accountability. And so my point about Section 33 in the context of the Section 3 litigation is this. It is that it is not just Section 3 that requires a robust interpretation of democratic rights, which it does, but Section 33 does as well. And in this way, Section 33 fortifies Section 3 and the rights of meaningful democratic participation. That's sort of the core of the argument. And then from there, it follows that, and we know this to be the case, that Section 3 cannot be limited to the bare right to vote. The Supreme Court has said that, but also includes rights of participation and voter access to information. And so what I end up with, and I hope I am able to explain this clearly, is that there's a bit of a paradox going on, and I like to think that there's even a little bit of a subversive argument at work here, because Section 33's principle of democratic accountability demonstrates why the override's attempt to stymie electoral discourse cannot work, and why Section 3 must prevail in these circumstances. There's much more to my presentation. I see that I'm well within time, so I'm almost done. I didn't think I would have time to flesh out the other parts of the argument, which are less to do with the override per se, but there is a sort of a second, slightly subversive element in the argument, which has to do with the City of Toronto versus Ontario, which Peter invited me to act sore about, because I was on that case as well, on the Section 2B argument, not on the argument about unwritten constitutional principles. And I guess I'm pleased to be able to rely on City of Toronto versus Ontario in the Working Families Bill 307 litigation, because the court in City of Toronto versus Ontario very clearly said that unwritten constitutional principles can be used to interpret the textual provisions of the Charter. That includes, in my opinion, not only Section 3, but Section 33 as well. And you can count on me to bring all those clippings and other things on the democracy principle and the principle of democratic accountability to bear on the interpretation of Section 33 and Section 3. I think the key point I wanted to make this morning is to point out the symbiotic and synergistic relationship between Section 33 and Section 3 as it arises in this Bill 307 litigation. I would say that Section 33 strengthens Section 3 at all times, and the court has seemed to say so in a number of cases. But I would say especially when the override has ousted Section 2B's rights of democratic participation. And I would conclude by emphasizing that Section 3 cannot be timid in these circumstances and cannot be timidly interpreted in the face of override legislation that undermines the integrity of the democratic process by interfering with rights of democratic participation. So the paper, when it's done, will give due attention to the other elements that I have not addressed this morning, namely exactly how we work the democratic principle and democratic accountability into Section 33 and Section 3. And there's also a lot to say about Section 3 of the Charter and its participation rights, the right of meaningful participation in the democratic process, and the right of access to information that can influence the vote. I mean, I think one of the challenges is that the predecessor litigation focused on the rights of Section 2B Charter applicants, and this current challenge has to shift the focus to the rights of voters, and it's very important in that context to have sound working theory of what it means to guarantee voters the right of meaningful participation in the political life of the country. So I'm looking forward to finishing the paper and perhaps hearing some questions and comments. Thank you very much.
Well, that was fabulous, Jamie. Thanks so much. I hope in the Q&A we'll have a chance for both you and Dwight to address the question of what is left of democratic participation when Section 2B is, if not eviscerated, sort of put to the side, and what is, in your conception, meaningful democratic participation, which you emphasize, other than the formalities of voting and participating in elections. Thank you so much for that. Benoît Pelletier, I am delighted and honored to ask you to come to the podium. I think most people do know who Monsieur Pelletier is, an esteemed law professor at U of O, and was a member of the Charest government for a period of, I think, close to 10 years. Yeah. So thanks so much for being here, and we look forward to your remarks.
Thank you very much, Peter. I would like to thank the organizers of this conference for having invited me to this conference, which brings together different visions of Section 33 of the Charter of Rights and Freedoms. And I would even say different visions of Canada. Of course, my vision of Canada, my vision of Section 33 are influenced by my past. I am a jurist, I'm a lawyer, and I'm a professor at the Faculty of Law of the University of Ottawa, and I've been a member of Quebec's National Assembly for 10 years. And as such, I have a profound respect for the judicial instances, the judicial courts, but I also have a profound respect for the legislative assemblies and for the governments. And I think that the main role of Section 33 is to try to find a balance, a sane balance between the judicial process and the legislative or the governmental process. And that is what I will be focusing on over the past minutes. But first, I would like to remember this. I know that for some people, the use of the Notwithstanding clause by Quebec is seen as being problematic. But it should not be forgotten that Quebec did not accept the Patriation of 1982. And Quebec still does not accept that Patriation and the Charter of Rights and Freedoms that comes with the Patriation. And I will tell you that, and maybe I have the opportunity to detail that question, to give more details about that question when there will be the question and answer period. But I will tell you that Quebec did not adhere to the Patriation, not just because it was not part of the negotiation itself, but because of what the Patriation did contain. It contained limits on the powers and the authority of Quebec's National Assembly. And Quebec did not adhere also because of what it did not contain. It did not contain the revision of the distribution of powers, more decentralization of the federal system, and more flexibility in the application of the Canadian federalism. And you may say, or you may think that there was no deal possible with René Lévesque and the sovereignists. You're right. But even Robert Bourassa would not have agreed with the Patriation. Even Jean Charest would not have agreed with the Patriation. I participated in a government that did not agree in the Patriation and did not subscribe to it and did not decide to officially adhere to the Patriation of 1981-1982. So that should not be forgotten because the Notwithstanding clause is one of the only instruments, is one of the only means that still exists today that allows Quebec to express his particular political position about repatriation. That should not be forgotten. And I would even say that the notwithstanding clause is one of the few instruments, I wouldn't say one of the only, but one of the few instruments within the Canadian federal system that allows Quebec to express its diversity. Quebecers, I would say that many Quebecers, not all Quebecers, but many Quebecers are proud Canadians, but they want to be Canadians their way. They want Quebec's specificity to be more recognized in this country. And the question comes, is federalism flexible enough to allow the expression, the affirmation of Quebec's specificity? My answer is yes. And at the source of that Canadian diversity is the notwithstanding clause. The notwithstanding clause is one mechanism that allows provinces or political entities within Canada to express their originality and therefore to celebrate Canada's diversity. And too many Canadians, in my view, have a vision of Canada like if it were a unitary state. And during my political career, I had to fight that. I remember that there were occasions when I was in politics, and I'm a federalist. I was pleading for Canada and Canada's unity and Canada's federalism. I was pleading for Canada's federalism all over the country, and there were occasions when I said to people from the west part of Canada, we in our government, we are open to discussing the Western alienation. There should be an end to this alienation. I was saying we want to put into place the Council of the Federation in order to, and we did it. We want to put into place the Council of the Federation in order to strengthen the relationship between the provinces and the territories in this country. And we want a just federalism, a fair federalism, and we want to negotiate with the federal government in order to have different agreements that would satisfy both parties. There is one thing that I would ask you in counterpart. It is that there be more respect for Quebec's diversity within this country. And when I said that, when I was saying that, there were people who, in fact, denounced my words or were against my words, just because I mentioned the respect of Quebec's diversity within Canada. Could you imagine? So my point is that the notwithstanding clause is something that helps Canada's unity. Some people don't realize it, but it helps us building a stronger Canada. Because my point of view is that Quebec's specificity and Quebec's originality within Canada is a great Canadian asset. It's not an obstacle to Canada's unity. It helps building a stronger Canada. I really appreciated before the remarks of Dwight about the choice that was probably made by the constituents between sections 2 and 7 to 5 and the other sections of the Charter. My own explanation was that when you look at section 3 to 6, these are rights that are related to Canadian citizenship. When you look at the mobility rights, these are rights that are related to our country, to our socio-demographic and sociologic context as a country. And when you look now at linguistic rights, you look at political rights, rights that have a political nature, contrarily to the other rights of the Charter of Rights and Freedoms. So I think that the Constituent made the choice of putting these rights and liberties connected to the country, connected to the socio-demographic context of Canada, beyond the scope of Section 33, and to make, and now it's amazing, but it's the case, to make the other rights and liberties that have a more universal sense, that have a more universal dimension, within the scope of Section 33, in fact. So that's my explanation of that choice that was made by the Constituent. And I see now the Supreme Court of Canada, in some of its cases, saying that the rights that are within the scope of Section 33 are of a major importance because the Constituent decided not to put them within the scope of Section 33. So the Supreme Court of Canada says if the Constituent decided not to put them within the scope of Section 33, it's because they have a major importance. And because they have a major importance, we should ask for a more severe justification from the states. So there's a link between Section 33 and Section 1 of the Charter of Rights and Freedoms. But it should be the opposite. There should be a more severe justification for the rights that are within the scope of Section 33, because in that case, the legislator may have the last word. In other words, the tribunals could be more severe with those rights, knowing that finally the legislator could decide to have the last word on these questions. And to me, Section 33 is plainly and mainly about who should have the last word on certain subjects. And this is not easy to decide, of course. I think that on some subjects, the last word should belong to the legislator on some subjects. Because I know that the tribunals are extremely, focused on the respect of individual rights and liberties. But the tribunals are less focused on collective rights or collective interests. And sometimes when collective interests are at stake, in my view, it is just normal that the last word belongs to the legislator. I think it's a bit ironic, and I don't say that pejoratively, but I think it's a bit ironic to ask ourselves, is the notwithstanding clause in accordance with constitutional democracy? Well, notwithstanding clause is more democratic than a decision that is rendered by a judge who is non-elected. Notwithstanding clause is a decision that is taken by the representatives of the population. So in my view, notwithstanding clauses have an explanation by themselves within our system. I don't think that they should be used all the time. Of course, there should be a very, I would say, delicate, thoughtful use of notwithstanding clauses. But at the same time, I think that they are useful in our system. Do they go against federalism? No. Again, because they express Canada's diversity, or they be used for the expression of Canada's diversity. Do they go against democracy? No, because in fact, they are part of our democratic system. Do they go against the Constitution itself? No, because they are part of the Constitution. They are part of those compromises that were at the basis of our Constitution. And let me tell you that I insist on the fact that they should not be used all the time. They should not be used in a way that is not reasonable. The idea that there should be some justification when they are used is an idea that may be examined closely. As Nathalie mentioned, there might be some desire for some explanation. In the Hack case, Justice Blanchard from Quebec Superior Court, mentioned that there should be some connection between the objectives that are followed or pursued by the legislator and the notwithstanding clause. He wondered whether there should be or not some connection between both. He didn't go as far as requiring a rationale, or he didn't go as far as requiring a justification by himself. But at least he asked for some connection. Maybe we'll go there eventually. And I'm concluding with this. Maybe we'll go there eventually. I don't know what. But let me tell you that view from a Quebec's perspective, viewed from a Quebec's federalist perspective, the use of the notwithstanding clause is sometimes highly justifiable and highly justified. Thank you.
Merci beaucoup, Benoît. Fabuleux. Très, très important. I guess, we'll have discussions about the distinction between collective rights and maybe collective interests. And of course, your point is well taken. Alan Blakeney, essentially makes the same argument about different kinds of collective interests in a different context. But then again, you have to address the issue of minority rights in that context, right? Or minority interests in that context. So we have a few minutes for questions, and I am certain that you have some, or comments or interventions, and I would invite you to speak, and that includes our speakers. Any of our speakers, please just use this opportunity as time to engage. And I see that Monty has his hand up. So I'd ask you to come up to the, and I'll move my stuff away from here. Nathalie and Jamie, you can sit here, make room for you. And I'd ask you to come up to the microphone and put your question to the panel, to any of them, and try to make them questions more than comments or more than lectures.
Monty McMurchie. First of all, my compliments to everyone who participated in what is most interesting. Going through my thought process, listening to all of you, is Hans Kelsen, the Austrian-American legal philosopher, in terms of positivism and what he always was looking for, the Grundnorm, that law based on norms, fundamental norms. And I'm going to suggest that the norm that we ought to be ascribing is that in terms of good civics, that those people that seek elected office in terms of what are their aspirations, and all else falls from that. And I pose to anyone who cares to respond, is how do you calibrate? How do you adumbrate what you're saying in terms of legal jurisprudence, which is precision, must be based on precision and precedent, and at the same time advancing the conversation in a manner that is deferential, respectful, and being subject to what I call the unwritten codes in terms of a base precedent. But I say the norm. Where are our civics? Thank you.
Thanks, Monty. Does someone wish to respond to that? We have two former members of the legislature and two former cabinet ministers who could probably address that. Nathalie, do you want to respond in any way?
But I would say that I think it is incumbent on all of us to continue to engage into a deliberation, and the idea that you provide multiple fora for deliberation in front of the courts, in legislature, and in civil society generally, I think is what we're all about. I would say that the last 40 years of charter jurisprudence has precipitated different big issues being debated in all these three forms. Medically assisted aid and dying is a good example. You know, it starts someplace, then it has to move somewhere else. People continue to think about it and evolve. So the point I was trying to make is that let's create more occasions for deliberations, not less.
Okay, thanks, Nathalie. I'm going to ask those answering to come up to the podium when they answer, because unfortunately, the viewers online do not hear your responses. Guillaume.
Yes, thank you to all of you. It was very interesting. So yes, I'm Guillaume Rousseau from the Université de Sherbrooke, and I guess my question is for Nathalie, but if the other wants to jump in, I'll be glad to hear from everybody. My question is about the suggestion you made, if I understand correctly, that there should be a link between the level of deference towards the legislator and the parliamentary procedure. So if the parliament does examine very carefully the question of human rights, maybe there should be a higher level of deference. So the way I see it is that it supposes some kind of micromanagement of this parliamentary procedure by the courts of law. Is that, do I understand correctly? And my other question would be, is there a problem? Is there an issue here with parliamentary privilege? Thanks.
Yeah, so Eileen Kavanagh suggests that ought not to be a micromanagement by the courts of the process. Rather, she suggests that the process of justification would refer to the process that was used in terms of deliberations and so on. So she suggests this as being one of the elements that should be looked at courts and evaluate. And I see that a little bit the same way as when, it's not a perfect, but when the courts under the Sparrow test, for example, demand consultation from Indigenous people by saying, unless you've consulted, we're not interested in a process of justification, or at least we want to pay attention to that. So it's at that level, a macro level of requiring the government to justify its process as part of how it justifies. I actually think it may create some self-discipline within the legislative branch and some self-discipline within the executive branch as well, to avoid bypassing too quickly all the processes of consultation. In terms of parliamentary privilege, I don't think that it necessarily would have an impact. I think the public records would be there to be assessed. So anyway, that's one of the theories that she suggests would be interesting to look at.
Richard Moon from Windsor. Yeah. If I have to direct my question to somebody, I guess maybe Dwight is the best person, but I'm not sure it's directed in particular. As people point out, judicial review, certainly in 1982, we thought about it, rested upon an awareness that legislatures sometimes failed to take adequate account of individual and minority rights. But there was obviously anxiety about giving significant authority to courts. So we all understood, I think, Section 33, even though there was anxiety about it. But I wonder about two changes that have occurred in the political life of our community since 1982. And one of them, maybe most people won't pay much attention to, but has been a fairly dramatic shift in politics to the right. And if anybody wants to dispute that, just think about where the conservative leaders during the Pierre Trudeau era, what their politics were, Robert Stanfield and Joe Clark. But the other, I think, is a growing lack of awareness or maybe an indifference in the larger community to politics as we understood it, I think, once. And one manifestation of that has been the indifference to breaches of political conventions. The answer was always, when a political convention was breached, that there would be a democratic or political response. And we certainly saw, and my politics are obviously coming out here, in the Harper government, frequent breaches of such conventions and a complete indifference in the general public, it would seem, or lack of knowledge of those conventions. And I wondered, to what extent is the increasing anxiety about Section 33 the result not just of its growing use, but of these two related factors: the move to the right of our politics, and then our growing sense that especially so-called populist governments are not really in this day and age particularly accountable to the public, at least in a very specific way. And my concern is, are we looking to the removal of Section 33 or at least its curtailment, and in particular, the reliance on judicial review as a remedy or a response to the collapse of our democratic politics? And I don't know whether it's, how effective that can be. Anyway, I had one quick question just about Quebec. And that is, in 1981, surely there was some live question about who spoke for Quebec. After all, the Trudeau government held virtually, maybe it was every seat in the province of Quebec at the time, and I think no seats west of Winnipeg. And so there was a real live question about to what extent the Trudeau government could be said to have spoken for Quebec. Anyway.
All right, so we'll let Benoît respond at the end. Or, well, you can respond first if you want. It doesn't matter. And Dwight, why don't you start? Fantastic questions. Thanks so much, Richard.
Sure, thank you for the question. I mean, the first claim about the shift to the right is complex, because I think there are shifts both ways. There are always political ebbs and flows. I'm sure that for some people that gives rise to anxieties about the Notwithstanding Clause, but we obviously can't determine anything normatively about how the Constitution should work based on what temporary political factors have occurred. And populism may be a different issue. If populism is defined in some way other than just a Democrat that you think is a little crass, or that you don't agree with, but if it's about an appeal to baser instincts or something along those lines, or an abandonment of conventions, then certainly that could give rise to some distinctive issues. I would just say there are complex things to say there too, because democracy and representative government shouldn't be available only to those who can talk like lawyers and can act like judges when they're in a legislature. It needs to remain open to a diverse set of representatives and not be overly judicialized in a response to a concern about populism or something else. And so I guess I'd just say, yes, I agree a lot on the issue about political conventions and accountability. I don't know if that's a concern just about so-called populist movements, though. I think we've seen a general decline in respect for those conventions by all sides, and that's a huge concern about how our democracy is going to work generally. And I agree, Section 33 and whatever debate occurs about that probably isn't a solution on that, but we need to do a lot of other things to rebuild foundations for democracy and civics education, whatever those might be, to try to make those conventions meaningful again.
Thank you. Benoît, did you want to respond? Okay. Oh, sure. Benoît, can you respond to the question about what? Yeah.
Yes, the question.
Yeah, about whether the Trudeau Liberals spoke for Quebec versus.
Yes, that's right. Well, you may ask the same question for any collectivity, of course. Who speaks for Canada? Is it the minority government of Justin Trudeau, or the NDP Liberal government? Or the question may be asked for anyone or any collectivity. This being said, what is true is that the Charter is very much respected by Quebecers at this moment. And even, I would say, cherished by Quebecers. Not many people do remember what the patriation was about, to be frank. But of course, the stand I took, or the position I took, was that of the institutions, the official institutions of the Quebec government that I was part of. So officially speaking, there is no question for any political party in Quebec to accept the patriation of 1982. And Quebec is still looking for constitutional reform. That is, of course, obviously extremely difficult to make, to say the least. But who speaks for Quebec on these questions? Well, I would say that there are two orders of government. Each order of government has its own interests, and the clear position of the official Quebec institutions is to be against the patriation. Then you may ask yourself, why are there so many people who invoke the Charter? Why is Quebec using the amending formula like it did a couple of years ago with regards to schools in Quebec? But the reason is that the Charter and the Constitution apply to Quebec. So Quebec has no choice but to deal with it and to make use of it when it's needed. But the Charter is extremely appreciated at this moment.
Just before you sit down, Nathalie's going to answer, but a follow-up to your comment now. You're saying no government in Quebec and no party in Quebec accepted the patriation. And I think that's correct. I think it's absolutely correct. But just out of curiosity, what does that do for Jean Charest's credibility at the moment as he seeks the leadership of the federal party? Does that, I mean, in a serious way, it was a serious question. How does that, I mean, you served in his government. What do you think, is he in a difficult position now because of that?
No, because of course he has to explain how he became a conservative, a liberal first, and then he is still a conservative. And there's a song in Quebec that says, let's get rid of the liberals. And yesterday night, Jean Charest was at a TV program, and they had that song, let's get rid of the liberals, because now is the leader of the Conservatives. But not the leader, but the candidate for the leadership of the Conservatives. But to be frank, Jean Charest comes from the Mulroney government. Mm-hmm. And that government tried the Meech Lake Agreement, the Charlottetown Accord. Sure. So I think that politically speaking, he's in a good position in this regard. I'm not talking about the rest.
Okay. Merci.
I just wanted to speak about whether or not the use of a notwithstanding clause is only a right-wing phenomenon. I could imagine, I think in the paper I thought that it was an equal opportunity for all governments to use a notwithstanding clause. You could imagine a more left-wing leaning government wanting to use it once it's been used by others, just because you can and because it makes you powerful and makes you like as though you're taking this issue so seriously. So an example would be the bubble zone around abortion clinics. You can imagine that a left-leaning government would say, I don't, I'm so certain that I want to protect access to abortion rights that I want to protect that, and I want to put my stamp on it and use it as a wedge issue to bring out on the other side, the idea that and to oppose it. So to me, the fact that the notwithstanding clause then becomes a political tool is what worries me, as opposed to a deliberative way in which it should be justified on all grounds. And I think justifying it as being whether it is a reasonable limit in a free and democratic society would help ensure that it's not overused. So.
Nathalie. Marion.
Good morning. Great to be here, and thank you all for your presentation. I noticed you've all presented kind of different, very nuanced views of when it might be appropriate to use the notwithstanding clause and what safeguards may or should not be in place. But I don't think I heard anyone specifically comment on Quebec's recent uses of the clause. So I would like to invite anyone on the panel who's interested in doing so to comment on Quebec's recent uses, Bill 21 and coming up in Bill 96. Thanks.
Well, Monsieur Pelletier testified on la loi sur la laïcité, so I know he's got a strong opinion. Come on. Sorry.
Well, I would say that to me it doesn't fit the protection of minorities. On Bill 21, it doesn't it does not reflect the protection of minorities on written principle. I think it is vulnerable at international human rights law, and that's the reason why I think it would fail. But certainly, I think in my imagination, it has to be justified under Section 1 first, debated under Section 1 first, and then debated on whether or not on Section 33 it's even necessary to go this way. In my view, it probably would fail on both counts. But to be further.
Zvi, did you want to offer a response? Did you have a question?
I had a question, but I think I'm fine.
Okay, that's fine. So there's an online question which really could be offered to any panel and every panel, and I'll read it. It's from Basma Al-Farouk, who says, how can we balance the use of the notwithstanding clause with the primacy of judicial review guaranteed by the fundamental rights in the Declaration of Human Rights and other international conventions to which Quebec has subscribed? Does anyone want to respond to that? Yes.
First, I'd like to point out the fact that when I testified before the Superior Court of Quebec on the Bill 21 case, I did not support the bill. I did not say I was against it either. I argued that the last word should belong to the Quebec's National Assembly. And it was in a context where I'm a bit, I would say, annoyed by the very strong judicialization of our system, of the Canadian system. But I will not emphasize that point now because I don't have the time to do so. But there's a context that explains the use of the notwithstanding clause by Quebec. This being said, I brought with me the Hague decision, the decision from the Superior Court of Quebec. It's a 240-page decision about a bill that was subject to Section 33 of the Canadian Charter of Rights and Freedoms. So the notwithstanding clause do not prohibit judicial review. It has an effect on the sanction of unconstitutionality. That's the point. But it does not prohibit litigation. It does not prohibit judicial review. This is something that we should, in fact, put aside clearly, in my view.
Discuss when Robert Leckie gives his talk on that. I appreciate that you said that. Dwight, you want to add something?
I'll just add that in many ways, the use of the notwithstanding clause answers for the moment, the Canadian constitutional questions while it's in force, or at least that would be my view of the legal effect of it. But that's obviously going to be litigated. But there are opportunities for people to put challenges in terms of international human rights law to international bodies, and they should consider doing that. The one thing I would say is that the conclusions from international human rights law may not always be what people anticipate. And notably on these issues, people that cite the European Court of Human Rights for all kinds of other things should look carefully what the European Court of Human Rights has said on these particular issues, because what Quebec has done is not totally dissimilar from what a number of European countries have done and had that upheld in European jurisprudence. And we can disagree with that, but it may be within the scope of international human rights law for it to do that, but that could be tested out.
Thank you. So we're almost at the lunch break. I just wanted to ask maybe Jamie and possibly Dwight just to elaborate a little bit on the question I put after Jamie's piece about what really remains of meaningful democratic participation absent Section 2B rights. Because if you carve Section 2B out, because of course it is subject to Section 33, whereas Section 3 is not, as you quite rightly pointed out, what is the meaning? What is a meaningful right of democratic participation without the Section 2B component? And we know that the court, of course, has ruled on this in the City of Toronto case in first instance, or in second instance. Well, the second instance, the court said there's no infringement in the first place. In first instance, the court found that freedom of expression was actually infringed. In first instance, it was Ed Balababa did, and then that was overturned on appeal. But you get the drift.
One thing it's kind of interesting to remind people of is Thomson Newspapers versus Canada. Was that 1997 or 1998? It was a 72-hour ban on opinion polls. It was the 72-hour opinion poll blackout just prior to the election day for federal elections. And what's interesting to me about that, thinking about the question that Peter has raised and some of the thinking around Bill 307, is that Justice Bastrash wrote a very strong Section 2B opinion. And he commented, I think it was in his discussion of deleterious consequences, he commented quite vehemently about the degree of interference with voters' right of access to information that was posed by the withdrawal and the ban on just 72 hours worth of opinion polls in the at the end point of a federal election. So when I look at some of the restrictions that have been discussed and some of the interference in City of Toronto and then under Bill 307, we're a long way from a simple 72-hour opinion poll blackout. And so I guess I would take the view that where we're talking about rights of democratic participation that have to do with the election process, once Section 2B is gone, there's a real challenge and a real risk to the integrity of the democratic process. And, I think Section 3 works in this particular instance that I've spoken of this morning, but I'm not 100% sure it would work in all the situations where eliminating Section 2B could put the integrity of the democratic process and the principle of democratic accountability very direly at risk.
Thank you very much, Jamie. So thank you, panelists. It was a wonderful morning. Thank you for your presentations. Thank you for your questions. So we'll adjourn now for lunch.